The CPI report, Child Protection in Iowa, is brought to you by Vocal, Victims of Child Abuse Laws. You can watch our program on Mediacom Channel 15 in the greater Des Moines, Iowa area. This is on Sunday at 1 o'clock p.m. And again, we repeat the program at 9:30 p.m. on Wednesday. And for those that are watching in the Council Bluffs, Iowa, Omaha area on Cox Cable Channel 23, you can pick up this program every other Thursday at 4:30 p.m. You can email us at vocaliowa@mchsi.com. We like to receive phone calls from the parents. We try to help on a one-to-one basis. My number is 515-276-3956. John's number is 515-282-2672. My name is Don Burgmaier, and with me at the controls is my co-host,
John Harvey, and I also do a little switching, and you probably saw some switching at the beginning of the program that looked like it was going down through all of the cameras that we have in the studio. And on one of those cameras is a gentleman that feeds us some information about the court system, and his name is Terrance Walker, and he gives us some good information about what we should be coping with, or how we should be coping with the court system, and what we should be doing with judges that are not doing their proper jobs.
how many hundreds of controls do you have over there, John?
Well, we have a system that is supposed to be handling four cameras, but we also have switches that share all of the channels with all of the other inputs that we have. And one of those inputs are color bars that we set up for the Cox cable requirements. And there are other features such as such as this one here that tells us when the program comes up. All kinds of other things that we can put on from time to time, but we have to switch them into simply four video channels. We do the best we can with the equipment that we have. It isn't extremely expensive equipment like you would find in the commercial studios, but it does fit our needs, and we're so pleased that we can come into the living rooms all over central Iowa and all over western Iowa and deliver a message that we think is important to families from time to time. Last week, we saw, as a part of our presentation, we saw some things in the Department of Human Services. It was their budget hearing, and people came and were complimenting the board. This is the DHS council. They're appointed by the governor, and they're supposed to set policy for the things that go on in the Department of Human Services. And one of those policies, of course, is the budget. And so these people would come forward and thanking them for all of the marvelous money they got in years past, and saying that we sure do need that to be continued for this coming year. So we're going to give you 5 minutes of our begging and our insight on our own organization. I wish I had taken shots of all of them, but I picked four of them, and we tried to get all four of them in last time, but we had one of those video glitches in which we had a problem getting one of them on the last one on the air. So we're going to do what we can to get that one back on the air and see if we can't improve on our production. Let's see what happens here. The fellow that you're going to be listening to his name is Kim Schmidt, and he heads an organization, a coalition of all kinds of family service providers. And so what they do is they pool their money and hire one person to go over and lobby in at the Capitol and to do all the coordinating necessary that they get their funds to run their particular organization. And so he was speaking on behalf, I think it was 33 different organizations that he works with and for. But his name is Kim Schmidt. Let's see if we can be a little more successful in getting him on the air this time than we were last time. Here now, before the Department of Human Services at their recent budget hearing is Kim Schmidt. We'll see if we can't get him up on the screen here.
Executive Director of the Coalition for Family and Children's Services in Iowa. My members represent most of the major organizations that run children's homes, children's shelters, and provide services to children and families in the state. I want to thank you for the opportunity to address you this morning. Last year with the legislature, this is my third year, I think, in addressing you, and at times it seems very frustrating because we keep hearing the same refrain over and over of we don't have money, we don't have resources, we've got to make do with less or more efficiently and so on. That's one of the reasons I wanted to talk to you today. The department last year requested and helped us get a 3% increase last year. That was the first time providers have had an increase in it would have been in 6 years. It's pretty much a cost of living. But the good news is at least we aren't dropping any lower, and the department helped us get that, and we're very, very appreciative of that. With that said, 3% for a coming year doesn't make up for the losses of the past 5 years, and we still have a children's system that is very, very much in crisis from underfunding. And again, I don't have to tell you that. I'm here because your letter asked for ways to discuss partnering and sharing and hopefully working together. And one of the things that I wanted to talk to you and be very brief about, hopefully this morning, is an example of what we went through, or what we have been going through in the past year with our children's shelters in the state. When I talked to you last year, we had 23 children's shelters in the state. Today, 3 of those shelters are out of business. They just simply didn't have the funding and they had to close. It was a crisis and it was coming up, and the department and Director Concannon recognized that we had a crisis, and they came up with a solution for that. Our proposal to meet our needs on that. And it was to offer a contract where they told shelters that they would have a guaranteed number of beds that they would get paid for, so that they could count on that income coming in, instead of some months having almost no children in but they got paid for, other months having lots of children. Now, children's shelters and providers that run children's shelters depend almost entirely on the department for their sources of income. So it's very important for us to know whether we're going to have kids that we need to care for or not. And I think children's shelters are the basic, that is the basic level of safety net in the state. I think it's critical we have those. The RFP came up with a guaranteed number of beds. We think it was a good plan. The department was working with a limited amount of resources, and we thought that that was a problem. Because you can't, no matter what the best plan is, if you don't have the money to implement it properly, you can't get there. So the coalition went to the legislature and talked to the legislature about it. The legislature agreed, and the legislature, when your appropriations bill came out, increased the number of beds. We were talking about an initial RFP for 240 to 250 beds. It appears that that was issued for about 240 beds. The legislature said, let's raise that to 288 and have 15, they call them at-large beds. We think that that's a help. You tell us, we come to you and you say, we don't have money, we sympathize with you, we want to help you, and we want to work with you also. We as providers have some resources, such as lobbying and so forth, that you don't necessarily have access to, and we can help. We think it can be a very effective partnership. But so far, we aren't getting any indication that we're ever going to see our extra beds that the legislature went to. If we don't get them, a good plan is probably still going to see several more shelters shut down. Right now, if you live in south central Iowa and you need a children's shelter, say mom and dad get arrested at 2 in the morning for meth and you need to take the kids somewhere, guess what? Those folks are probably going to go to Metro Des Moines area. That's not really neighborhood services for kids. And I think having a shelter in every neighborhood is critical. We want to help you. We want to work with you. We think this is an ongoing process. But at the same time, when we're working with you, if we can solve a problem, if we can get you more money, the money needs to be directed to where the services are being provided and with the kids. And we'd like to continue in this partnership. Actually, I don't think it's a partnership, and I don't mean that negatively. I think it's closer than that. I think it's almost a family relationship. We're siblings, brothers and sisters, big brother, little brother, whatever. But DHF is our big brother. Big brothers make decisions for their siblings that have an impact on their siblings. And everything you do obviously has a major impact on how we provide services. We need your help, we want to help, and we want to work with you. But I think the shelter example is a very, very key area of how we've gotten a long way down the road on partnering. We've accomplished some very, very good things, but we really need your help on this when we have rolled up our sleeves and tried to help the situation too. We look forward to more opportunities like that and hope that we can keep fighting for kids, because right now it's a rough world for kids out there in Iowa. Thank you very much.
Well, that gives you an idea of how agencies and people can come before the Department of Human Services and give them suggestions about what they should have in their legislative agenda and what they should have particularly in their budgetary agenda, because the more you can beef up your story, the more they're likely to shell out precious taxpayer dollars. Not dollars that they have contributed, dollars that they have managed to squeeze out of the Iowa public. Well, I promised that we would talk to Terrance Walker here in just a moment. Following his presentation, and I hope he has some other things after we get another presentation completed here, but Don and I are going to talk a little bit about something called the Megan Registry. And we're going to look at that from a historical perspective, and then we're going to look at it from what it is doing to people in today's world. It's a rather tragic thing. It's costing us over $1 million a year to run the Megan Registry, and there is some wonder if it is doing what it is supposed to be doing, or is it just bothering people who have already completed their sentences, is it really set up and performing as it ought? Sometimes we find people in police work and in these areas of enforcement that they seem to get off track and don't really care much about something that we hold dear, and that's called the United States Constitution. That Constitution we hold dear because it is a protector of the rights that we hold dear. The rights that are not given by the Constitution but are given by God and supposed to be guaranteed by the Constitution. Here's the gentleman that we're going to be talking to. His name is Terrance Walker. Belongs to an organization called A Matter of Justice. Also has another organization called VJO. That's called Vote Iowa Judges Out. That means that if you find judges who are not performing in accordance with their orders, then we don't need those judges in place. And we don't have a system whereby we can vote for our judges to vote them in, but we do have a system whereby we can vote them out. That last one down there where it says www should say www.amatterofjustice.org. Here now, Terrance Walker.
Thanks, John. And Don, I appreciate the opportunity to be on your show every week and explore some issues and have some dialogue. Too often we, in society, we get dumbed down by the run-of-the-mill regular radio stations and TV stations, and we don't really have any interesting dialogue that is not beyond 4th or 5th grade comprehension anymore. But thank God for this show. Anyway, yes, I am the self-proclaimed judge of the judges here in the
You may be hitting your cough button.
and I guess I'm hitting my cough button, so you can't hear me. But yeah, I'm the self-proclaimed judge of judges, and boy, it is hot in this studio here. You say, pretty hot day today. But anyway, yes, it is everyone's right, duty, and obligation, I feel, to discern what's going on in the courtrooms, not only in this state, but also throughout the nation, because it is these agencies or these government bodies that are sworn to and should implement the rights that are supposed to be protected to us by the Constitution. But yet and still we see incidents every day where the Constitution is basically torn to shreds by despotic, lawless judges that do not care one bit about what the law is, but what they feel it should be. And as long as they have their personal opinion, they feel that that should matter more than what the Constitution is basically there to protect. And we live in what is called republicanism. Republic. Republic, going back to the original Latin meaning or original Roman meaning to basically publish laws. I know there's a lot of talk recently after the election about what a republic is supposed to mean, but it originally goes back to the Roman meaning, which means to have published laws. Well, we have published laws, but what happens if those published laws are being basically torn asunder and disregarded by a lawless band of people who are supposed to honor those laws, but instead want to choose their own personal view of what the law is? And we have in Ohio just a recent case of what this has all transpired into. There's a group of individuals that have a website out in Ohio called Erie Voices, E-R-I-E Voices.com. And this story comes to us from the Empire Journal, the Ohio News Editor, Tuesday, July 19, 2005. And here we see this is a common example of what judges will do in their personal opinion. Now, we've got two people that's part of this website, Erie Voices, that's E-R-I-E Voices.com. Elizabeth Baumgartner, who's age 50, is a licensed pharmacist and also a former attorney. She's disbarred attorney and government critic. She's long been a critic of the judicial system in Iowa. And her business partner, Brian DuBois, 28, of Sandusky, Ohio. Both of these people, part of this website, are facing criminal charges for their comments relating to and activities relating to their challenges to the judiciary. And I find this interesting because in the United States, we're supposed to have what's called the First Amendment, freedom of speech, that's supposed to protect not only our right to redress grievances, but freedom of speech, but other rights as well. Well, we see that if we have in office some despotic, tyrannical judges that are hell-bent on pursuing their personal agenda, then we see that those rights basically have no meaning. And when we break the law, it's called a crime. The average ordinary person, it's a crime or a criminal action, and we're given a citation, we're given a fine, we're put in jail, we have all kind of other attendant circumstances or penalties that emanate from that as well. However, when a judge violates the law or the Constitution, they call that an interpretation. Well, in the case of ErieVoices.com, this guy, Brian Du Bois and Elizabeth Baumgartner, both have been charged with intimidation, 3 counts of retaliation, and 1 count of possession of criminal tools. Du Bois, he faces 1 count of extortion, 2 counts of intimidation, 1 count of retaliation, and also 1 count of possession of criminal tools. Now, it's kind of sketchy what they're relying upon, but apparently the judge filed a complaint with one of the judges filed a complaint with the Cuyahoga County Sheriff's Office, and he was alleging that the Elizabeth Baumgartner had filed a couple of federal lawsuits in Florida and Ohio against him to prevent him from presiding in lawsuits pending against him. And then Brian Du Bois, who's also part of Erie Voices, he allegedly gave a note to a school superintendent after that superintendent testified against his partner, Elizabeth Baumgartner, during the libel trial last year. And but the whole thing about this case is that not only is it stemming from this alleged note that one of the guys did, but also the filing of a federal lawsuit. Now, we all have a right to petition for redress according to the First Amendment Constitution. We're supposed to be able to file lawsuits. And, you know, 99.9% of the time, well, I should say 100% of the time you file something against a judge, it's going to get thrown out. I have yet to see a case where it's not going to get thrown out. So just to say because it was a lawsuit that was thrown out, it's a criminal matter now because you filed a lawsuit against me, is dead wrong. But the funny thing about this is that the criminal tools that these guys are supposed to have been alleged to have been in possession of are computers. Now, this is what I'm talking about. When we talk about an interpretation and a crime by a judge, this is a prime example.
I was going to ask you if they had pencils or something and considered those as criminal tools.
Well, imagine if they had pencils. That would be a criminal tool. Now, a pencil can be used as a criminal tool, but a computer, I mean, what can you do? You can type it, you can save it, and you can save files, and you can type stuff on there, or print stuff out.
Send viruses.
Well, yeah, but these guys were putting words out that were critical of these judges. Being critical of judges, being critical of anybody is a protected speech. You know, unless that speech is supposed to be reasonably construed to constitute fighting words, it's not something that can be criminally sanctioned. Yet, we have apparently judges who are willing to partake this this route and try to pursue this because they feel that they need to be vindicated, and their honor or their reputation is probably a little less or a little more tarnished. Well, if you're doing your job, and we're in the United States of America, you have no right to go to pursue a criminal action because your reputation, the average ordinary citizen doesn't. So why should a judge be able to pursue a criminal action based upon his reputation? Anybody else, if you went down to the police station or the prosecutor's office and you got you were mad because someone, one of your neighbors or associate or friend or somebody that you know had said something to tarnish your reputation, and you wanted to file a criminal action against them, you would be laughed out of that office. But yet and still, here we have an incident of a judge whose reputation may have been tarnished, maybe rightfully so. And yet and still he's able to pursue the most craziest of interpretations of a criminal statute, which is saying that the criminal tools which were used against this judge, which are in possession of the defendants, are computers. And the article goes on to state that the charges against the government critics, Baumgartner and Du Bois, are reminiscent of the charges and convictions obtained against gun rights activist Rick Stanley, a Denver businessman who was sentenced to 6 years in prison for allegedly threatening 2 judges. Stanley was arrested for writing letters and filing motions pro se, which the judges claim were attempts to influence a public official. He was accused of sending the judges a notice of order, demanding that they reverse his conviction for weapons violation or face arrest by Stanley's Mutual Defense PAC militia, and a trial for treason for allegedly violating their oath of office. One of the judges had convicted Stanley and sentenced him to 90 days in jail for carrying a firearm onto public property while campaigning for public office in 2002. The other judge upheld the conviction when Stanley appealed. Stanley argued that his sentence and record should have been voided after Governor Bill Owens signed a law limiting local governments from regulating firearms. Now, these two in EerieVoices.com, they have not did anything so substantial, so extreme. In fact, Baumgartner is one of the judges was sent an email, and Baumgartner's email was labeled as threatening. Now, when you say threatening, there's a lot of different ways that you can construe that. Well, he said that this judge that was supposedly threatening, or that it was delivered this threatening letter or email, said that it didn't threaten bodily harm, it threatened his reputation. And on the basis of that, he lodged an extortion charge. This is the most craziest of legal cases that I've seen the past couple of weeks. And I think it's due time that the judiciary be shown that who is the boss, and we should start voting these characters out of office. Did you have comment on that, John or Don?
I thought that was rather interesting, where they can redefine, they can stack the deck against somebody, and they can misinterpret what a computer is supposed to be doing and call it criminal tools. We don't have the criminal tools statute, I don't think, in Iowa.
We don't have a threat and a reputation statute either.
We already know what his reputation is, so how can
yeah, well, it should be. It really should be mud after this. And one of the things we see come to light here with the recent announcement of a United States Supreme Court nomination, and it's discussed every time a judge is brought into office, is their accolades and their background and how squeaky clean they were and how great they were and their legal opinions and all this. Well, I have an issue with that because a lot of times the true character of a judge doesn't come about and is never really discussed during that, and the true nature of the judge's character oftentimes can change. Should individuals, simply because they have a Harvard degree or a degree here or some sort of other accolade, should they be automatically presumed to have such a high degree of character that they're automatically considered a shoe-in for an office? I don't think so. Time and time again, we see that people that have these accolades and great accomplishments oftentimes have some real character issues in the fact that they're not just, these accolades and accomplishments don't make them just great. Well, that just means that a lot of times that means that they're great hiders. they've hide their character flaws.
Right.
And so there we got these guys here in office that secretly are crooks. You know, on the surface it might look good, but when they get behind doors, when they get behind these law books, when they get behind these legal opinions that they're writing, and these weird actions and interpretations they're putting out, they're criminals. And that's why I have been urging that people should be voting these criminals out of office. And I know that might be a harsh word. Well, saying that a computer is a criminal tool is very harsh as well. So I just thought I'd throw that in there. Did you have a comment about that, John?
Yes. When it comes time, you see, a judge is not supposed to be a politician. A politician is one who is supposed to be have the ability to slide around all issues and to make everybody happy with him. But I think a good judge is not one that has to have the applause of the public. If he's a good judge, he will have some enemies. If he's a good judge, he's going to make some decisions. In fact, about half of the people that appear before him are not going to like his decision, because half of the people are going to be dissatisfied with a negative decision from that judge. So he is in a job in which he creates his own territory. That is, he creates people who are satisfied with him and people who are dissatisfied with him. And I think he just has to live with that. I think that when we evaluate the judges, we don't evaluate them on the basis of things that are of a popular nature, such as a politician would have. You know, what a tremendous orator he is, and this sort of thing. I think when you evaluate a judge, you evaluate him on the basis of his staunch tenacity in digging out the truth from the facts, and his tenacity with respect to what he knows of the law, what is right. And also, one thing that I respect of a judge is when he stops and takes care to explain what it is he just did in making a decision. He said, "This is the way I'm going to approach this, and these are the tenets upon which my decision will be based." Those are the kinds of things that I think we use to evaluate a judge, not necessarily because he ruled against you, because maybe you should have been ruled against. Maybe you didn't have the maybe your case didn't have the merits. But he knows what his canons are. He knows what his ethics are. And I think if he violates those, he needs to find another job. Presumably not a job that is public service, because he's already shown that he can't be trusted with a job of that sort, and certainly a job that demands honesty and integrity and scholarship and a few other benefits like that. Well, that's my comment. It wasn't a brief comment, but that's my comment.
Oh, yeah,
Terrance.
well, it was appreciated. I did have a couple cases here. I wanted to always bring this back to Iowa, since this is Vote Iowa Judges Out, which is the organization I head. There was a couple cases. One that was in the Court of Appeals, July 13th, I thought I would discuss here, if you could kind of display that. This goes back to whether or not the interpretation is criminal. This case here, State of Iowa versus Danny Frericks, July 13th, 2005, Iowa Court of Appeals, decided by Judges Vogel, Miller, and Heck. I just thought it'd be interesting. This guy was convicted of possession of methamphetamine and failure to fix the tax stamp and OWI, basically. Well, this is a very interesting case because if you look at one of the issues he brought up was hearsay evidence. If you flip to the next page on there, I'll show you what I was talking about. The guy was challenging the admission of the supposed recipe of methamphetamine. Well, police seized a document located in his house which purported to be a recipe, and the district court ruled the recipe admissible, apparently agreeing with the state that the recipe was not offered to prove the truth of the matter asserted, and thus was not hearsay. And he appealed it. And this is what the Court of Appeals said here. We agree with the district court the methamphetamine recipe was not admissible hearsay, was not inadmissible hearsay. The significance of the recipe rested not in the fact it would actually yield methamphetamine. Now, doesn't that sound odd? Okay, this was a recipe that was purported to be a recipe for manufacture of methamphetamine. Well, this is what the weird logic of the Iowa Court of Appeals says. The significance of the recipe rested not in the fact that it would actually yield methamphetamine, but rather in the fact that something purporting to be a methamphetamine recipe was discovered in a home in which Friedrich resided. Okay, what are you telling me? That the pot is not black, it's black? You know, what are you saying? You know, these are the kind of things that you need to really discern when you're seeing if it's a good judge. If they're telling you something that doesn't make a whole hell of a lot of sense, then that's not a good judge. And the judge that wrote this opinion, Judge Vogel, apparently the clerk didn't get it right. You need to really examine what your clerks are doing, or you need to examine what you're doing and the logic that you're using. I think that every judge should have to take a logic class, because a lot of times you read these opinions, there's not a whole lot of logic to it. They'll just put a bunch of words together, try to confuse people that's reading it, and then if there's any sort of public furor over it, they'll say, well, this is a legal opinion that was very complicated, and we can't really discuss it because it's too complicated and it's over your head. Well, if you're sitting there telling me that the methamphetamine recipe wasn't significant to the case, but yet and still you're going to say that it's significant enough to offer it as a recipe, when you're saying that it doesn't have to be an actual recipe, what the hell what kind of sense does that make? Does that make any sense to you, John?
No way.
So, you know, basically it threw out this guy's issue, but, you know, you got to learn to read between the lines. Some of these judges, they'll try to pull a fast one on you. This is a fast one that is apparent from anybody with any 2 cents of knowledge or common sense, who can actually read through the lines and say, man, these guys are pulling a fast one. Just like they're pulling a fast one saying that a computer is a criminal tool. Or just like they're pulling a fast one by saying threatening a reputation is extortion. That's my comments on the matter. I thought we'd share some of the judges here on the Court of Appeals here. There's a picture of there's Court of Appeals Judge Gail Vogel. Yeah, that's the one that wrote the opinion. Now look at this. She's got all these accolades, yet she can't make sense out of nothing. Obviously, graduated from, where did she graduate from? Drake Law School,
Rockford College.
Rockford College, and you know, it just goes to show you.
In the order of the
All
Kof.
those honors and accolades don't mean a hill of beans when it comes to practicing fairly and coming up with rulings that make sense logically.
But it got her a job.
Well, yeah, something got her a job. It might not have been that. It might have been, you know, who she knew, who she was willing to do shiesty stuff under the table with. I don't know. Some of these people, I tell you, man, it's not like I said, it's not just ability to have these accolades. It's ability to hide and be in the Good Old Boys Network. When she made it to the Good Old Boys Network, she's not a girl, not a woman, not a boy, but she's a woman, but you know, there's a couple more on the next page too. I just think it's important that people see these judges here so we know who we're voting for and who we're voting out. Can't say a lot of good things about any of these people that we've seen so far. Judge Miller, Judge Hecht. I've seen a lot of opinions by these guys, you know, Hecht and Vogel and Miller, you know, that don't really make a whole lot of sense. Sometimes they're able to ignore the whole issue and skip it and claim that it can't be heard. And usually you don't catch anything that has a some twisted logic in it outright like that. Well, this is one case where her ability to hide the facts obviously didn't gel with the, you know, wasn't able to be hid from view. Also, there's a picture of the Iowa Supreme Court. I thought I'd share that with folks as well. Yep, there they are. There's Judge Liverato in the middle, or should I say Liverato or Liverato.
Down the bottom here?
Yeah, down at the bottom. And only one I don't think is on there is Wiggins. Oh no, there's Wiggins in the corner there on the right.
Judge Strait over here came from Polk County.
Oh, okay, I thought.
Stay with your mic.
Judge Strait. Okay. Well, I got a new name for Judge Strait. Judge Crooked. We've got Judge David Wiggins in the corner. He's probably the only one that I can say that is respectable.
Hey.
But yeah, Judge Liverato, Judge Crooked, and it was just there's a bunch of stuff going on here. But you know, as you could tell, I don't have a high opinion of the judges and the justice system here in Iowa. You probably wonder why. Probably because I experienced it firsthand, and I see that they do these kind of things on a regular basis. Next week, we're going to be discussing this book.
Is Eisenhower on there?
Yeah,
he came from Polk County.
Yeah. Well, I don't think it matters as much as where they're from as where their ideology is from. Because they really, their ideology doesn't make a whole lot of sense. This is a guy that we're going to discuss next week that wrote this book, The Rape of 2,500 Creditors by the United States Judicial System, an expose. It's going to be an interesting story. They've got a pretty good quote in the book. If you let me see that book again, I'll give you the quote. It was one of the funny things I found in there that he cited is that, if I can find it here real quick. One of the things off the top of my head, I won't hold up the show. One of the funny things he said off the top of my head, he said was that, you know, sometimes you'll find in some courts the finding of facts will basically be findings of fiction. And we just seen a prime example of a finding of fiction in this case here in the Iowa courts here. That's my take on the whole judiciary for this week, and I'm just going to give the show back to you guys.
Okay. Well, I thank you. I told you that I would be talking both in a historical perspective and in a current perspective with respect to the what we call the Megan Registry. It's called the Sex Offenders Registry, and it was they put it together hurriedly in 1993. They didn't have very many candidates to put on then, but there's been a growing enterprise to put what we would think of as a scarlet letter on anyone who has served his time for some offense, and the offense doesn't have to be sexual abuse. In one case I looked up, it was an offense of burglary. The guy is on the Sex Offenders Registry because of a burglary. Well, at one point, an editorial came out. This is a lead editorial in the Des Moines Register, and this was back in 1998. It was only 5 years after they had started this registry. By 1994, Megan provision came through Congress, and of course it had all kinds of money available to the states if they put up a registry. Well, we'd already started one in Iowa, but we certainly didn't want to turn down any federal money, so they worked on it, improved it, put made it match whatever the requirements are of the Megan registry and collected all kinds of money. And this thing is still going, and it's costing close to $1 million. It says, rethink the sex offenders registry. Branding potential offenders is fraught with practical and legal problems. There are many good reasons to question the value of Iowa's new sex crime registry. Among them, the law is so poorly implemented that it may be worse than having no registry at all. At last week's series on sex offenders registry, by the way, this came out in 1998, the editorial, and we haven't done anything to follow up on this, of course. Why should we rethink something that the Department of Public Safety wants, and Tom Miller's department wants? He's brewing up all kinds of things up there in Tom Miller's department. I think they ought to pull down that sign about Department of Justice and put up Miller Brewing Company, because he's brewing up things all the time. In last week's series of Sex Offenders Registry, Faults in the System, registry staff Lynn Okamoto wrote or reported that Iowans have not been notified the whereabouts of hundreds of convicted sex offenders despite a new law designed to promote for notification. In Des Moines, for an example, officials have notified the public of the whereabouts of just 13 offenders officially judged likely to commit new crimes. Citizens have not been notified of 200 or more potential sex offenders. Of course, those numbers are really way up now. Even if Iowa had sufficient resources to keep track of every offender, the state approach to notifying the public of the location of sex offenders often does more harm than good by stirring up fear and resentment and creating serious potential for acts of vigilantism and violence. In one case, officials got the wrong address and unnecessarily agitating neighbors and angering an uninvolved apartment owner. As for the targeted offenders, many live in constant fear of harassment and violence from their neighbors. Outside experts warn that Iowa is asking for trouble. Said a Seattle police detective who advises other states on sex offender registries. If people think they are picketing by chasing an offender from an address to address, that's going to keep them safe, they're mistaken. Even Iowa law enforcement officers like Des Moines Police Captain William Johnson worry about the law's impact on constitutional rights. To be branded, that's akin to being tarred and feathered and being repeatedly run out of town. It is obviously time for the state to re-examine whether this law, as written and implemented, is meeting the state's goals. And no one seems to worry about looking after this recommendation. Iowa's sex offenders registry law is modeled after New Jersey's Megan law, enacted after Megan Kanka was killed by a twice convicted pedophile. The idea is that when a person is convicted of a violent crime, is released from prison, the public has a right to know about it. Putting that concept into legislation and a workable policy is more complicated, however. At best, identifying which offenders are likely to commit new crimes is an inexact science. You can underscore that. It's a big guesswork. An error either way has the potential of putting unaware public at risk of unfairly tarring the convicted offenders who have paid their debt to society and who pose no further risk to committing crimes. In any case, there are questions about the wisdom in empowering the government to mount a publicity campaign to warn the public about individuals considered likely to commit violent crime. Our criminal justice system was carefully constructed to provide an array of protection for criminal suspects against being wrongfully accused, convicted, and imprisoned by the state. Nowhere in our system of justice is the government granted the power to single out and brand individuals as potential criminals. People convicted of a crime, even sex crimes, have the right to be free of government harassment once they have served their time. Surely there is a better, more humane way to protect the public from sex offenders. Judged by the state to pose a serious threat to society than labeling them as monsters and hounding them wherever they go. Iowa lawmakers and law enforcement officials should think long and hard about fundamental fairness and effectiveness in this law. It cannot be improved. If it cannot be improved in its execution or its effect, it should be scrapped. Good idea. Well, in today's world, let's look, and we'll call on Don to give us a story from a recent article by staff writer Jennifer Jacobs, and also contributing to this article is an old friend of ours by the name of Frank Santiago, who used to do articles on the Department of Human Services for the Register. In Floyd County, they're doing all kinds of silly things, and this particular article tells about how they're rising to use the Megan Registry to harass all kinds of people up there simply because they're on the Megan Registry. Don?
Okay, John. In Charles City, Iowa, authorities have used the sex offender registry in their investigation into the death of 5-year-old Evelyn Miller, Floyd County Attorney Marilyn Dittmer said Tuesday. Dittmer said she wasn't certain how many offenders have been interviewed, but the registry was among the tools investigators had employed in an effort to find the girl's killer. Authorities have not released the results of the autopsy on Evelyn's body, which was discovered in the Cedar River 6 days after she disappeared from her mother's Floyd apartment July 1st. Police have not said Evelyn was sexually assaulted, but relatives have said they believe she was. The Iowa Sex Offender Registry lists about 6,000 offenders statewide, with 5 listed in Floyd County, including one who lives next door to Evelyn's maternal grandmother in Charles City. 2 offenders said Tuesday that police knocked on their doors shortly after Evelyn's mother reported her missing July 1st. Another couldn't be reached by the Des Moines Register. The 5th man, Roy Koblenz, a registered sex offender who lives in nearby Green, said he was surprised that he had not been contacted by officials in the case. They never came by, said Koblenz, who was convicted in 1993 of 2 counts of indecent contact with a child in Chickasaw County. I was kind of expecting them to do that, but they never did. Also Tuesday, Evelyn's mother, Noel Miller, and her live-in boyfriend, Casey Fredrickson, were in Floyd County Court for a hearing on custody of their 2 children, Gabriel, age 2, and Damien, age 1. The toddlers were put in the care of Fredrickson's mother in Floyd shortly after Evelyn's disappearance, but were placed in foster care outside the area July 12th, records show. About 7 p.m., July 11th, she called 911 because Fredrickson and Miller were causing a disturbance. Floyd County Sheriff Department records show. She told the dispatcher that they'd be trying to get their kids and they are not supposed to have them right now, and they are starting to cause problems. Floyd County Associate Juvenile Judge Gerald Maggie, who had placed the 2 boys in foster care July 12th, closed Tuesday's hearings over the register's objection. Juvenile hearings were open to the public unless the court determines that the possibility of damage to the court outweighs the public's interest.
The damage to the court? That's interesting.
Let me repeat. The judge closed the hearing.
Okay.
That means that the public is not allowed to be in there, or in this case, the Des Moines Register, because the judge was a little nervous, I guess. So, one way to put it. Or maybe one of the attorneys or parties were. Judge Maggie said that although the Frederickson children are too young to be aware of comments made at the hearing, the comments certainly may affect the children in third-party ways other than directly. The judge's ruling was sealed, but a family friend said Miller and Frederickson volunteered to leave the boys in foster care. The couple had a visit with the two toddlers at a Charles City public park later in the day. The parents declined to comment on the case. Just before the hearing began Tuesday, Dittmer, the county attorney, asked Miller and Frederickson if they had taken their urine analysis test, to which both nodded yes. Urine tests for drugs typically come into play in a child custody hearing only if there is some prior knowledge of drug use, said Roger Munns, a spokesman for the Iowa DHS. The test can be recommended by a child welfare worker, the county attorney, or a guardian ad litem, but only the judge can order the testing. DHS workers have been involved with Evelyn's family before her disturbance, but Governor Tom Vilsack said his record of reviews showed that the workers handled the case properly. Meanwhile, Randy Petrie, one of the two men who were among the last to see Evelyn alive, said he discovered a tracking device on his car Monday night that he believes was attached by investigators who had recently used a search warrant to seize his car. Quote, "I dismantled it and totally destroyed it," said Petrie. "I'm hoping it's a very expensive device because I'm giving it back to them in about 600 pieces. If they want to know where I'm at, all they gotta do is ask me. I ain't got nothing to hide." Petrie, 32, said he and a friend, Don Slick, were driving home from a night out drinking and stopped to visit Casey Frederickson. Evelyn answered the door, but the man said they left when she told them Frederickson was asleep. Slick, 27, had said authorities told him during the questioning that Petrie is their prime suspect, but investigators have not said that publicly. Petrie said investigators have asked a female friend of his to tape record a telephone conversation with him. Now, I'll turn it back to you, John.
Okay. I wanted to make sure that I've got the story in there regarding them actually tapping the automobile belonging to someone on the Megan registry, and they have no right to pull this off. And I thought it was interesting that he was going to return it in 600 pieces. They're ticking these people off when there is no probable cause for doing so. Well, I want to thank you for stopping by the CPI report. We will see you next week.